schools, charitable organizations. And likewise, other opportunities for the municipality, not the Planning and Zoning Commission as much as the town council, to regulate the use of cannabis products on municipal-owned property. Since then, the Department of Consumer Protection, a couple of months ago, did adopt the policies and procedures required to effectuate Public Act 21-1 and some 54 pages of regulations, which implement the 303 pages of Public Act 21-1. And in recognition of the fact that Public Act 21-1 is lengthy and complicated and raises a lot of new legal issues as well as planning and public safety issues for Connecticut's municipalities, many municipalities have been approaching the issues raised by Public Act 21-1 in a variety of manners, the most common of which has been to adopt a moratorium with respect to the establishment of cannabis establishments. And the tracker that I provided to Mike last week that we've been updating on a weekly basis since last July, we've got 102 towns or so that we're tracking so far. 68% of those towns have adopted a moratorium of some sort and of varying durations, ranging from a few months to a year or more. Cheshire has filed an application that's before you tonight that triggered the public hearing, seeking to amend its regulations to adopt a temporary and limited moratorium for the reasons that I indicated. This will allow the commission the time necessary to fully review and evaluate the issues raised from a planning and zoning perspective by Public Act 21-1. And to the extent that you decide, based on the process that you'll undertake, to make some other amendments to your regulations to address regulation of cannabis establishments, the period under the moratorium will provide you an opportunity to do so in a thoughtful and professional manner. So that's the genesis of the application for a zone text change. That's the proper mechanism under your zoning regulations and under Connecticut General Statute Section 8-3 to accomplish the consideration and adoption of a moratorium. It's not a ban, it's not a prohibition of cannabis establishments. It is a temporary limited moratorium. So during that period in which the moratorium is in effect, if you adopt this text change to your regulations, then yes, cannabis establishments will be prohibited, but it's not a permanent ban. Some municipalities, a dozen or so, have in fact, in one way or another, adopted regulations or ordinances that completely bans cannabis establishments. But again, the purpose of the moratorium, it's limited in duration so that you have an opportunity to focus on, study, and assess in a meaningful and responsible way the impacts of this new law on the town and whether in fact you have a need for regulations of cannabis establishments. Happy to answer any questions about the proposed amendment or about the state of the law.
Okay, thank you. Mr. Caderas, I see your hands up.
Yes. The state of Connecticut is going to be a highly regulated industry no matter what the town does, correct?
Well, it is going to be highly regulated in the sense that you've got a 303-page public act and 64 pages of consumer protection regulations. So I wouldn't disagree with that.
And and possibly or likely there are probably going to be more regulations from the Consumer Protection Agency once they get upgraded and going. Would you
I
think
would,
that's fair to assume?
I would expect that's reasonable.
Okay. And does Cheshire regulate liquor stores or tobacco sellers?
Does Cheshire regulate from a zoning perspective?
From the zoning perspective.
Well, I mean, sure.
Just for the record, Mike Glidden, Town Planner, no. You treat liquor establishments just as any other retail use. There's no separation distance. There's not a special permitting process for a package store to open up in town. It's as long as the property is zoned for retail, you allow that use.
And that's the same for tobacco as well, correct?
Yes.
Thank you.
Mr. Natale.
I got a few things. I'll just go through them all if that's okay.
Sure.
I thought it was, so I was looking, sorry, these are my notes here. So around us, just so folks know in the audience, Waterbury has a moratorium. And again, the moratoriums are different lengths of time. Prospect, Bandit, Bethany, no smoking on town property. There's no other information on Bethany. Meriden allowing it, limiting the number of establishments. Southington, Wolcott, Wallingford have banned. And actually it was interesting for Wallingford because Wallingford, I think in your notes said that something is against federal law or state law. They're not going to allow anything. So they're taking the stance federally, you can't do it.
Right.
So they're not going to allow it. Hamden's got a moratorium. So those are the towns around us. So if we enact a moratorium through next January or whatever period we choose, again, if somebody comes up with an application, it sits because we can't do anything with it until the moratorium expires, or before the moratorium expires if we make another decision either to allow or to put regulations in place.
Correct. You can always amend your amended zone reg.
Okay. And at the end of the moratorium, if we don't do anything, what happens?
Well, at the end of the moratorium, it reverts to the status quo, whatever the law is at the
Okay.
time that the moratorium expires.
Gotcha. So if we put in the moratorium, again, my thought is we have to do something if it's for a year in the next year, either to allow it, regulate it, or ban it. So we'd have to come up with some type of regulations to address that. From what I remember in the Public Act, there is an option for a public referendum. What are the rules around that?
Well, that's a regulation by referendum is something that is specified under the act. And as I discussed back in July, right now, in terms of interpretation, we don't have any. We have what the legislature wrote in Section 83 of the Act, which is that upon petition and subsequent vote at a regular election, municipalities can prohibit all recreational sale of marijuana or limit recreational sale to certain types of sellers that have been established under the Act and are licensed by Department of Consumer Protection. And so if you have a petition by at least 10% of the electors of the town file with the clerk at least 60 days before a regular election, then you get one of three questions put on the referendum ballot. Those questions under the act are, shall the sale of recreational marijuana be allowed in town? Or shall the sale of cannabis under, and then you would identify a specific type of license or licenses be allowed in town? Or shall the sale of recreational marijuana be prohibited in town? So it's one of those three questions that you can get on a ballot upon petition of at least 10% of the electors of the town.
Gotcha. Going back to what Mr. Carderas was asking too, we don't regulate liquor. We don't regulate cigarettes, but those are also legal federally. So it was, like I said, it was interesting what Wallingford did there. I know we're talking about the moratorium tonight, but I want to ask you a question about our regulations. So we have a regulation around adult establishments. They can't be within 2,000 feet of schools, nursing homes, nursery schools, daycare centers, residentially zoned properties. Have you seen towns moving towards regulations like that, where they're limiting, if they want to have them in town, where they can actually put them?
That certainly is part of the discussion that's going on in other towns that we represent, as well as other towns that haven't taken any action yet with respect to an ordinance or a zoning regulation, because of the fact that that is specifically identified in the Public Act. You've got right now existing law prohibiting smoking or vaping in certain locations. So, that'll be expanded to include the space within 25 feet of any doorway. But in terms of school buildings, smoking and vaping is already prohibited on school grounds. So really the discussion has to do with those categories: churches, hospitals, veterans' homes, nonprofits, and private schools really is what the discussion in other towns is focused on.
Okay. And you mentioned about the smoking in town properties. So that is something that town council will handle because that's an ordinance, correct?
Correct.
Okay. So I would recommend, regardless of what we do here, I'd recommend the town council take a look at that. And, it's not technically right now considered smoking. It's not considered vaping. If I'm incorrect, please correct me. So right now, if somebody wanted to come outside of this building, or they could, correct? And smoke?
You're talking about cannabis?
Cannabis, yes.
Correct.
Okay, so I would recommend the town council probably take a look at that since that's not under our purview. I think that's it for now. We'll probably have a couple more, but thanks.
Sure.
Mr. Tesco.
Because a question, you may or may not be familiar with this. With respect to medical marijuana, marijuana still is in most cases illegal under federal law. With medical marijuana, I think the Justice Department, the U.S. Department of Justice, at one point had a memorandum or a policy that said they wouldn't challenge medical marijuana laws or medical marijuana establishments that were operating in accordance with state law. Is there anything similar like that for recreational marijuana, as far as you know?
No.
So the federal government might well consider a cannabis dispensing facility in Cheshire as being illegal under federal law.
I think, the expectation based on what I've read in terms of states that are ahead of Connecticut in legalizing adult recreation use of marijuana, the expectation is that the Justice Department will follow the same protocol as it has with medical marijuana, but I'm not aware of any formal position being taken yet by DOJ.
Thank you.
Go ahead, Mr. Kaderis.
Didn't DOJ under an amendment of the same letter, I believe it was by an assistant attorney general, that in fact that they expanded the medical marijuana non-enforcement to state laws, so long as under conditions that it wouldn't be marketed to children, it wouldn't be crossing state lines, and it would be regulated by the state. Didn't the DOJ do that as well with recreational marijuana?
Not that I'm aware of, no. I know that's the expectation, because I know when Connecticut was about a year ago having various levels of debate, there was a lot of discussion about the expectation of other states that DOJ would follow the same practice as it does with medical marijuana. But I'm not aware of whether or not there's a formal amendment to that letter.
Okay, I have a question a little different. I believe it'll come up in a public comment tonight too, but hemp, how is hemp classified? And specifically for Cheshire, being a cultivator of hemp, would it fall in the same regulations as our moratorium?
If you look at the proposed amendment that's on your agenda tonight, we have a definition section, section B. And B1 states cannabis means marijuana as defined in section 21A 240 of the Connecticut General Statutes. And if you look at 21A 240, 21A 240 subparagraph 29 defines marijuana. And at the end of that definition, it says, unless derived from hemp as defined in section 2261L. So the definition that's in the proposed amendment to the regs tracks the definition in 21A 240, which excludes hemp.
Excludes hemp.
Correct.
So it's not part of, okay.
Correct. Says
So
unless,
hemp would be
unless
excluded.
derived from hemp.
So hemp would be excluded from our moratorium.
Correct.
Okay.
Yeah, we're not doing anything to, this is limited to this proposed moratorium under this proposed text amendment is limited to that which is created under Public Act 21-1. It's not an attempt to go beyond the scope of 21-1.
Okay. Mr. Natale.
Yep, just remember the last question I wanted to ask. So I haven't read anything different, but last time you gave us an update, the state was dangling the carrot of a 3% tax that would go to the town based on sales. Is that still a fact?
Yes, it is.
Thanks.
Okay, commission members, we can come back. If no one else has any questions, I was going to go to the public. Okay, anyone from the public wishing to speak on this? We just need you to come up to the microphone over here to my right and give your name and address for the record, please. Yeah, come on up. And if you, yeah, perfect. Just need your name and address for the record, and then whatever you have to say.
Well, I don't live in Cheshire, but I can give you my business address. Is that what you want?
If that works for me, yeah.
Okay. My name is Brant Smith, and my business is located at 35 Diana Court in Cheshire. And it's a greenhouse facility. We have almost 65,000 square foot of space. I've owned it for 20 years. I've been doing business here for 20 years. And for the last 2.5 years, I've been growing hemp in our greenhouses, which is, as most of you know, a very similar plant to marijuana. They're both cannabis. And the only difference is the amount of THC that's found in marijuana versus hemp. I'm interested in getting a license for recreational marijuana, a micro cultivator license, which is up to 10,000 square feet, which is approximately about 15% of my greenhouse. As I understand this moratorium, I believe that the definition of cannabis establishments includes cultivation, and I'm looking for that to be taken out if you do decide on a moratorium, because I'm not selling to the public at all. I am just growing. I think given the history of Cheshire being the bedding capital of Connecticut, it seems that I should be able to grow. We're not going to be doing any retail there. It's purely and simply, if I get the license, and I'm looking to do a social equity license at this point, because that's the first lottery that they have. And again, I don't know how familiar people are with the licensing and whatever, but I'm kind of in a pickle because they just announced the first lottery, and for a micro cultivator license, it's February 10th, and it would go for 90 days. So if cultivation is included in this moratorium, then I'm out of luck. So that's why I'm here, I guess. And if you have any questions, please feel free to ask me.
If it's 90 days you have, does that mean,
90 days for that lottery. Then there's another lottery.
let's say you
So
won the
forth.
lottery in that 90 days, how much time do you have?
You have, I believe, a year, but I believe when you apply, you have to have a valid location. And if
Which
there's
you do.
Not if there's a moratorium. I don't believe on my property. I don't know. As you know, all this is up in the air. It's crazy how complicated it is. But I would believe that they would throw my application out if I didn't have a legal place to grow. So I think if you win the lottery, and believe me, I mean, again, I don't know how familiar people are, they're offering all of 2 microcultivator licenses for the state for social equity, and then another 2 non-social equity after that. So that's what it is. I don't think that my application would be accepted when there's a moratorium because they don't know if the moratorium is going to be continued. It's going to go forever, whatever. So that's why I'm here, because I believe the definition of cannabis establishments includes everything. And I believe what you're most concerned about, and I would be too, is the sale to minors of the marijuana, which I'm not doing at all,
Sure.
or intending to do at all either.
Mr. D'Onofrio, is most of the towns that we have on this list here, are they also including cultivators on their moratorium?
The moratoria are based on the definition of cannabis establishment in the Public Act, which includes cultivators.
One town took out cultivators.
I mean, it doesn't mean you can't, but just to answer your question, the regulation has been focused on the definition of cannabis establishment rather than parsing specific types of cannabis establishments.
I'm sorry, yeah.
You have a question for me?
Yeah, just who would you be selling to?
Who would I be selling to?
Yeah, like a whole, I mean, how's that work?
Dispensaries. I have to obviously build up distribution, but it would be within the state, and it would be, probably medical dispensaries, any dispensaries that are existing now, plus other ones that are put in, would be where I would go. Also, I would have the potential, I believe, issuing 5 licenses initially for food. It could also be put into food. Like I believe in Middletown, it's been okayed, but those are the places, dispensaries and maybe a bakery, things like that.
Where you put the cannabis in it, you mean?
Oh, yeah.
Okay, so like gummy bears you're talking about, kind of thing.
I presume that, yeah, gummy
Okay,
bears we
I'm
could
just
put, I
curious.
I intend to grow it for the flower, which
And then you would sell to someone else that makes
I
them.
would, I'm selling it to somebody else that has a manufacturing
Just
license.
curious, thank you.
Yeah, sure.
And you said 10%?
It's about
10,000 square feet, I mean, I'm sorry.
10, the micro cultivator license, you need a minimum of 2,000 square feet and a maximum of 10,000 square feet. So I have about 65,000 square feet of greenhouse space. And so 15% would be devoted to marijuana, and the remaining would be devoted to hemp at this point.
So you're only allowed to do 15% of whatever the size of your
No, it's not the
operation
15%, it's the 10,000.
is? It's 10,000 square feet.
Yeah.
Now, I've never grown it. I don't know how much you can get out of it, but we're going to have 4 licenses of a maximum of 10,000 square feet in the state.
Yeah.
And will that be enough?
Do you want me to start on this?
That makes no sense to me. It doesn't seem like in
You
10,000
know,
square,
it doesn't
40,000
make
square.
sense. So here's the issue, and this is my feeling, and forgive me, this is how I feel about it, but there was a lot of talk in the beginning how this was going to be great for small businesses and also social equity people and whatever. The 4 medical marijuana people, they're all licensed. All they have to do is convert to recreational marijuana. They're allowed to grow 250,000 square feet per facility. All those facilities have been purchased in the last year for over $100 million by out-of-state operators. They are also allowing people, anybody with $3 million to give to the state to build a facility in a social equity neighborhood. Doesn't have to go through the lottery. I'm not certain how much they can grow, but I think they get as much as the medical marijuana people. I'm anticipating there's probably going to be 3 or 4 of those type of people, 3 or 4 of those groups that come in. So that gives you, if there's 4 groups and it's 250,000, and I'm not sure that it's 250,000, but it's pretty substantial, or you wouldn't put down $3 million before you.
So they would build this facility in the inner city?
Again, I'm not saying it's an inner city. It could be, it's in a social equity neighborhood, so that you would hire the people for the facility. But what I'm saying is, what I'm figuring is it's 2 million square feet of cultivation for that versus 40,000 after a year. That's after the second lottery. It's only 20,000 in the first lottery, which will be in May. So the 20,000 versus the 2 million is 1/10 of 1%. I don't like that, but I don't have anything to say about it. So that gives you some knowledge of just the scope of what's going on, in my opinion.
Mr. Strollo.
My biggest thing about cultivation is security.
Sure.
Like, how do you?
The
plan-
DCP requires, they just came out with, I believe your attorney would know this, but they came out with requirements with respect to security. You know, I'm secure now, but I would get much more because you have to. The DCP has issued regulations. You have to have a 12-foot fence completely circling the cultivation area. And it's got to be a certain gauge metal fence. You need cameras everywhere.
Well, then you could just see them stealing the stuff.
Well, then you
I
can
mean, do
get
you have
them.
a guard? Is there a guard there? Or does
There's
that-
no requirements for a guard,
Yeah.
but I think a 12-foot fence is going to deter people, honestly. I mean,
You've never had any theft since you've been doing the hemp at all?
for hemp, no.
No.
And we do have cameras and we have,
Yeah.
you know, security for sure, but the DCP is going to require a lot more.
Yeah, that's my big concern, because I mean, I
Well,
don't see
again,
how I don't see how you could grow that and not have somebody come and try and steal it. That's
well, you're legally allowed to grow plants as a.
no, I know,
priority.
but you know,
You know, if
it's
you
a
want to grow
score.
6 plants at your house, honestly, I don't, I mean, I don't share that opinion, but
yeah,
it could happen. But as I said, there's, the DCP has issued a pretty extensive list of requirements with respect to security.
yeah. Thank you.
Sure.
Mr. Natali.
Can you educate us a little bit about the cultivation? So you grow it, do you have to dry it? Are there fumes? What's the process?
I would say there's some fumes, but I think they're contained within our building. I don't smell anything outside of our building.
That's for hemp. So if you were to go,
Hemp is the same plant, really. Honestly, I don't know if anyone knows specifically, but it's cannabis. And the only difference is just the amount of THC that's contained within that variety that names it hemp or marijuana. So where I am located, the nearest neighbor to me is several hundred yards away. I'm not located anywhere near residential neighborhoods or churches or anything, because I'm at the end of an industrial park.
so if you're thinking about going for a license, then
Sure.
What are the regulations, or has Consumer Protection come out with any regulations as far as the emissions or anything of that sort?
Not that I'm aware of. I don't believe so. But I could be wrong. I've studied this a lot, and hope you realize that. But I don't know everything. Believe me, I don't know everything.
No, definitely. I mean, honestly, thank you for coming. You're definitely giving us a little bit of an education on it. But a couple of the things that you're pointing out are the reason for the moratorium. We don't know. You don't know exactly.
I know
what
that I'm
regulations are
not
gonna be.
selling this retail. I'm not giving it to children. I'm not having teenagers buy it at the facility. The facility will have extensive security. Those things I do know. I don't know if they're going to expand the licenses, for example, because the feedback I'm getting from people is this is just ridiculous, how many licenses they're allowing. But that's what I'm talking about in terms of I don't know. I do know what the requirements are from the DCP with respect to security.
I just realized why Watertown took out the facility, because they do have, they have a facility.
They have a
right by
medical marijuana
Yeah,
facility.
right by UPS, and you can't get close to UPS without smelling pot. I mean, it's that bad. So I mean, I would, but I don't. That's a big
I
facility.
encourage you got people
But I'm
to-
just saying that's a bigger facility, like 250,000. You said square feet.
Well, they're expanding like crazy right now. I don't know if
You don't know how big that
the
facility is.
facility probably is at 200,000 at this point. They're just building it
Yeah.
out.
Because like
But
I
I'd
said,
encourage-
I go up there a lot. I do service for UPS, so I go
Okay.
up there a lot, and you can't even get near UPS without smelling it.
Well,
So
as I said, I encourage you to come to my facility. And, Governor Lamont was there in October. The DCP was there in late November, and nobody talked about aromas or odors or what have you. They came out to kick the tires on my facility.
Yep.
And I will tell you right now, if you're outside that facility, 50 feet away, you don't smell it. Now, my smelling may not be as good as some of your people, but I don't smell it.
I don't know about the rest of the commissioners up here, but I mean, when we first started talking about this, I thought it was more the sale. The cultivator, to me, it doesn't really make sense. But I'm, only one person up here out of 9, but I think he makes a lot of sense. I mean, it's a business we have in town. He's not selling the product. He's growing it. I don't know. I'd be interested in taking it out if you guys, if people would agree with me, take the cultivator part out of this ban just to, so his business could go.
Well, if we were to take it out, then we have to draft a regulation, correct? For cultivation?
define it. That's what water.
Just take out the word cultivation.
Well, that's the issue, right? It's not just what you don't include in the moratorium. It's what you then do with what you don't include in the moratorium.
So if we don't
Because
include.
right now, you don't have any regulations for.
Right, so if we don't
cultivators.
include cultivation, and the state came out tomorrow and said, you know what, there's gonna be 50 licenses, that would open us up to 50 establishments if they all wanted to come to Cheshire, because there's no regulation, correct?
Well, that's one
Hypothetically?
example of what not having a regulation does. But even if they don't increase the number of licenses, you don't have any regulations.
Yeah.
So that's the downside to it, but that's your decision.
I do have a comment concerning that. It's my understanding that the licenses are based on population. And given Cheshire's population of 28,000, only one license, only one
For-
micro license,
Cultivation also?
micro cultivation license. One. Because of the population. If you had more than 50,000, you could have 2. But that's what they've done,
So at the most, we would have
is one.
one 10,000 square foot growing cultivation facility if we left it out of our moratorium.
Well, I think Commissioner Natale's question was if they change the law. I mean, anything's possible, but if they don't change the law, then it's population based. That's correct.
And I asked that for a couple of reasons, because from what I've read, this is iterative. So the state is going to make changes. And I'm just concerned about what those changes are going to be if we draft, or, we don't put a regulation in place, what we open ourselves up to if the state comes out tomorrow and says, oh, this is going to be a moneymaker and they want to do this or that, and we don't have that regulation in place to protect us. I mean, because again, if we put the moratorium in place, there's nothing that says that next meeting a month down the road, we can't draft a regulation for that, specifically for cultivators. So I'm just looking to protect us.
We have to look at Watertown's regulation. That's what we need to do.
I would agree with EJ in that I would like to be able to allow you to do that, because if it's going to happen anyway, I'd rather see it happen in Cheshire. If there's only 2 licenses, I kind of agree with what you're saying, that is that what you're saying, EJ, that you would?
To me, coming into this thing, when I saw the cultivator on there, I didn't really understand why we're denying someone the right to
To grow.
grow it. I mean,
Right.
he's not selling in this town.
Not unless there's a
I actually-
dispensary at some point.
Yeah, I mean, dispensary is what I was more concerned about. And I'm not saying I'm against it or for it or whatever. Just, yes, we do have to make some kind of regulations put in place for it. But as far as a cultivator, I was kind of unsure why we had it on there.
I know a little bit about the hoops that you've had to jump through. When that law was originally, like way back, it was going through, my husband's the head of the Connecticut Package Store Association, and they were talking about doing it through package stores. And the rule has just been impossible for people to, like you, to be able to do anything. And then you're saying people come in from out of state. That's really not fair. If you're a local person and wants to grow it, it seems to me that it's equitable because you already have a business here. I mean, equity is what we're talking about here.
Right, I would agree with you, but I'm a business person. I don't really hold it against those people from buying, if you have the money and somebody wants to
Right.
sell, I'm not against that.
No,
I don't feel I'm protected that way. I'm just trying to compete on an even field, which there's no way I'm going to be able to even at this point. But I'd like to compete, and I believe I can put out a high level product that can be, a boutique product, so shall we say, that people would prefer versus what's coming out of the medical marijuana buildings.
If I could, I just want to clarify, I am not against Cheshire continuing to be a farming community. Cultivation, I think, is acceptable. But again, just with not knowing a lot from the state, I want to make sure that we're protecting the town and ourselves.
Oh, absolutely.
And
I
we come up with
understand that.
regulations that make sense. If that's limiting the number of cultivators for our town, regardless of what the state does today, because they could change tomorrow, I just want to make sure that we're doing it the right way. So again, I'm not against it.
Right.
Just want to make sure that we have the proper regulations in place.
So you would be against changing our moratorium to not include cultivators?
I'm hoping that we're not going to vote on this tonight because we don't have a lot of people from the public here. So I'd like to get some more public input if we could, but maybe for that next meeting, we could have a draft of a regulation for cultivator to break off from the moratorium.
I'd like to see something more descriptive from Watertown, what they did, exactly how they defined it in your it just says that they changed it, they defined it differently.
My recollection, and again, we looked at 100+ of these towns, but my recollection is Watertown's carve out goes back to medical marijuana.
It goes back to medical marijuana only.
And so they're defining a cultivator as a grower under their prior carve out. But I can take a look at what they did. In other words, I don't think that they have.
So the regulation included before this happened that. So couldn't we look at that regulation and adopt it to us?
I'll get it for you, sure.
Yeah, I don't know, that might save us a lot of time and if it's something that we can work with.
Okay.
Well, just the last point, since you're discussing this in terms of time frame, I'm kind of under the gun because they're opening the licenses in February 10th.
Yeah, but you're asking us to give you a monopoly right
no,
now. So, I mean, we understand you're in a time frame.
I
but
would love a monopoly.
Yeah, but I'm just saying is that
But-
you're a businessman and you could take that business and sell for $100 million once you have that license. So
Not a
I'm just,
micro.
I'm just saying is that
Yeah,
like,
yeah.
it's like you are a
First off, I
businessman.
have to win the
If somebody
license.
offers you somebody money, you're going to sell the business. But what I'm saying is that we need to, if we're interested in this, we need to get something
Sure.
that's going to hold on our end also.
No,
So-
I understand that. But to go forward for me, I don't want to spend the money to go into the lottery if I'm not going to have a place.
Well, like I said, that's going to be up to you. You're the businessman that's making the decision. We still have to.
No, I
our
understand.
thing here.
I'm just letting you know that
No,
for
I
me
know.
personally, time is of the essence. And in terms of a monopoly, I don't have a monopoly. Anyone in the audience can apply for a microcultivator license and
True,
win the
but-
lottery. I
Yeah.
have to win the lottery.
That's right. You sell. Everybody has to put their. But in order for us to do that, we have to
Sure,
get something on paper that
Yeah,
says that
totally
you're
understand.
able to do it. So
Totally
that's-
understand.
And we
I
have to
just-
do it the right way without rushing through it.
I just want to make the point that it's
No, we
opening up in
Okay.
less than 3 weeks. That's all.
Go ahead.
Mr. Dawson.
Yeah, I don't know nothing about that marijuana stuff, so. But I do love kids and I worry about the kids, and that has nothing to do with you. I'm just sharing my personal feelings. But I think that we have a very good town attorney and he works for some towns that surround us. And to me, not knowing anything about it, I've never touched the stuff, don't know anything about it. I know hospitals use it on patients. So I'm totally confused, but that's beside the point. I don't think this is anything that we could vote on, at least I couldn't, because I don't really understand the concept of it. We're talking about a person that's a grower versus a person that sells it. How do they get it now? How do the hospitals, where do they get it from to treat patients and so forth? You know, I don't have the answer, so I couldn't even vote on this. I wouldn't be prepared, you know. I mean, my personal feelings, I represent the townspeople.
Right.
So what I think personally is really unimportant. You know, I have to represent the whole town, but
And I totally agree on that. And I recognize you need to do what's best for the town and whatever. I just came here tonight to make the point of what I'm doing or would like to do, and that I don't believe it impacts in any way young people and teenagers.
no, and I respect you and I understand that. The thing of it is you're asking for time.
Well, I'm not asking for time. I'm just letting you know
Will
what
you say
I'm letting you know what,
what happens
there is
to
a
you?
deadline. That's all.
Yeah, but didn't you say what happens to you in 13 days?
No,
Or did I misunderstand you?
there's nothing that happens to me. They are going to start the license process on February 10th for microcultivation. And I have 90 days after that. I'm going to assume your moratorium is going to be longer than 90 days
Oh,
or
yeah,
100
okay.
days. So if you decide to keep cultivation in the moratorium, then I don't want to enter the lottery, which will cost me substantial money.
Right.
So that's all. That's all. I'm just making that point. I'm not telling you what to do.
No, because I don't think you could, but I'm just saying, I
Right.
respect what you're saying and you sharing that with us,
Yeah, sure.
you know, and that's basically what I'm trying to say to you, but
Yeah, I just
it's
came to
kind of
make the
hit me
point.
because I know nothing about it. I understand you go by it on the street anywhere, but I wouldn't know what it is if I saw it. But I guess that's what happens when you're old.
Attorney D'Onofrio,
I feel that.
do you have any information or do you think anything about his applying for the license if the town had a moratorium? Because there's a lot of towns that have a moratorium, and I'm assuming they're including cultivators in there. Do you think he will be hindered at all if we had a moratorium on for 1 year?
Well, that's the exact effect of it. If you look at the language in section C of the proposed amendment, during the temporary and limited term moratorium, cannabis establishments shall be prohibited in the town of Cheshire, and the Cheshire Planning and Zoning Commission shall not accept, consider, or approve any applications, and hereby prohibits the issuance of any zoning permits to permit the use of a cannabis establishment in any zoning district in the town.
But from what I remember from licenses going back in the past, if you won your lottery, as it's called, you didn't have to start right away.
That's a different question.
That's what I'm saying. Is there anything hindering him from getting in the lottery? And if it's a true lottery, you have every chance of winning that anybody else could. I mean, I know people that did it the first time 10 years ago that weren't even in the business. They just threw their name in there. And then once they won, they contacted other growers in the state to say, hey, will you do this with me? I have no idea what I'm doing.
Right.
They won. That's why
But as I understand it, if they're going to have only 2 licenses, so they then review those licenses. And if the location that you've provided them is in a moratorium, they will then nix your license and go to the next person that they drew out of the lottery. So I don't think it's something where I say, I win the lottery, they say, great, oh, well, I got a moratorium, but it's going to end in like 10 months. So, and they say, great. I don't think that would happen. Because quite frankly, a year from now, another moratorium could be put in place. Or you may change the moratorium to a permanent situation, in which case I am out of luck. So that's just my point. And again, and you guys know this too, I mean, this whole community is all about agriculture and grow houses and greenhouses and what have you. So, you know, I think if you came to see my location, that would answer a lot of questions about odor or security or where it's located. I think you would find that it's in a unique spot to do this, actually.
I gotta get to the
Yeah,
anyone
sure.
else in the public. I didn't mean
Want me to go?
because
Or sit down.
no, don't leave.
No, I'm not, I'm not
you, Jay.
leaving. I'll sit down.
Sorry, Mr. Soma.
Just one quick note too, in the definitions, cannabis establishment means producer, dispensary, cultivator, micro cultivator, retailer, so on and so forth. The micro cultivator, you could exclude cultivator, but allow micro cultivator to keep the scale of the operation down. So you don't end up with a Watertown situation where you have this massive grow operation, but you still maintain small businesses or smaller grow operations. Just a point to share with everybody. The micro cultivator is at maximum 10,000 square feet. Ironically, the regular cultivator definition is not less than 15. So we could kind of have it both ways in that sense too.
Would another question for Attorney D'Onofrio: if we had this moratorium in place, would this exclude a medical marijuana growing facility coming into Cheshire?
No.
Okay, that's kind of pointless what we're talking about here then. We're talking about one small, well, I did, like you said, they could change the rules. Okay.
So,
Well,
so,
go ahead.
so what we're talking about is strictly recreational. So a medical marijuana grow facility could come regardless because it's medical, not recreational.
The moratorium applies to Public Act 21-1, which is adult use, recreational marijuana,
So-
not medical marijuana.
Medical marijuana, so you could put a huge grow facility for medical marijuana because we don't have any regulations against that anyways.
That's right.
Thank you.
Is there anyone else in the public who would like to speak on this? Mr. Kaderis.
Yeah, for me, the question is not what are the conditions of the moratorium should be. It's whether we should have a moratorium at all. This is going to be a very highly regulated industry. Just by looking at the statutes, and the state gets involved, just like it does with liquor, just like it does with alcohol. And anything that we do puts us at a competitive disadvantage with all the towns that don't have moratoriums. Does anybody believe that if they legalize they're going to change the regulations to allow people to have any kind of store, any place they want under any circumstances? As it is, the town is only allowed to have 2 establishments anyhow. And to me, The whole thing about a moratorium is a solution in search of a problem that doesn't exist and hasn't existed, and will put us at a competitive disadvantage from any other towns that don't have moratoriums. And I can't imagine any regulations the state would come down would make it affect negatively the quality of life in town. I mean, marijuana is existing in Cheshire. It has been here for 50 years. It's easily available and completely unregulated as it is. And my view on this is that we shouldn't have any regulations because the state will have very strict regulations. And that's my feeling on it.
Okay. Mr. Natale.
I'm a little different on that. So your competitive disadvantage of 68% of the 102 towns that have addressed this so far have a moratorium. There's a reason for that. From what I've read and from what I've heard, the state is still writing their regulations around this. So the moratoriums that these towns are putting in place, large part from what I read, from what I understand, is because they don't have everything from the state in front of them yet saying this is exactly what it's going to be. Like I said before, it's iterative. And putting that moratorium in place is not saying, no, we're not going to ever allow this. It's waiting to see what regulations are going to come out. I think it's June. Was it June they can start opening retail establishments? Again, reading after that, they're going to come out with additional regulations. If you read about it also, there is talk with the state, again, maybe speculation, but that they may increase the number or decrease the population so that you could have more in town. So again, the towns that are doing the moratoriums are waiting. They want to see what the regulations are going to be before they jump in and say, yep, let's go for it.
And my point is with the state writing the regulations now, it is a de facto moratorium until the state has its regulations.
Well, not if we can't listen to any applications that come in front of us.
I'm sorry?
Well, we're not, if we put the moratorium on us, we can't listen to any of the applications that come in front of us.
Right, but they can't open because the state isn't permitting it. So the state is effectively, there is a de facto moratorium going on right now
Until June.
till such time as the state has its regulations.
But if we don't like something in the state's regulations, we have to rush to come up with something else.
Well, that is possible, but again, this is, in my view, a solution in search of a problem.
I think it's a solution preventing a problem.
Okay, well, we all have different opinions up here. I mean, I don't know either. I kind of questioned it at first, but to be comfortable listening to our town attorney, he suggested to do it. We're not saying no, we're just putting a moratorium on so we can read and look at the regulations that are going to come from the state and determine if we wanted to be a little stricter on our regulations.
How long would you put a moratorium on for, though?
I believe this moratorium we had here was for 1 year.
1 year?
That doesn't mean the moratorium has to go for 1 year, and we could take it off if we wrote regulations next month, which would be kind of foolish because we'd have to wait till, if it's June. I'm not sure exactly when the state is supposed to come out with their regulations, but if we were very proactive at that point, we're not really, and we got rid of our moratorium and had our regulations in place, we wouldn't be behind the 8 ball to be accepting applications, I guess. Well, anyway, is there anyone else from the public that wanted to speak on this? No? Okay, so the thought is we're going to leave this public hearing open? All right.
I would say yes.
Okay. All right, so we'll leave the public hearing open.
Yeah, for clarity though, so, we talked about possibly breaking out that micro cultivator. So again, for our next meeting, I think that we should really look at the proposal for the moratorium and also have some regulation drafted around the micro cultivator. Or pulling that out and having the regulation in place. And Sean suggested maybe going, you said Watertown? Yeah.
Can we get a look at Watertown's regulation?
We'll certainly get that for you. Again, my recollection is it goes back to 2013, 2014 timeframe when they had an out-of-state medical marijuana cultivator looking to invest a lot of money in Watertown, and they carved the growers out at that time. And so when the adult use Public Act 21-1 passed, I don't think they've done anything to their, I think they just continued to exclude cultivators from their moratorium. So,
But if we had adopted that regulation, it would make us more attractive for somebody like that to come in and do
But-
that
but when
kind
you-
of facility, right?
right, when you say a regulation, are you talking about just carving out cultivators and or micro cultivators, or are you talking about carving them out and having a regulation that in some way restricts?
I would say both. I
Well,
would-
what
it
do
would
you
have-
have
it
in-
would
what do you have in
carving it
mind?
out and having the whatever the
Why would-
regulation.
Why would we restrict it?
No. Have the regulation what their regulation was if it would work for us. So that would make it more attractive. If somebody wanted to come in and build a big growing facility for medical marijuana, it would be allowed to do that here. That's what I'm trying to say, is that if that's what we wanted, if it's that kind of facility that you want, if you're looking for that. If you're not, then something that we could carve out where cultivation on the micro side, but at least they have something in place. We have nothing. They have something. I think we should look at what the regulation is.
Well, for example, just spitballing here, you're okay with it anywhere in town? It's consistent with your POCD anywhere in town?
No, I want to see what there, because it's an industrial area where it is right now.
Yes.
And it's away from everything else. You have UPS, FedEx is there, and there's really no houses near where that facility is. I mean, because I'm there all the time.
Okay, so you just
So-
want to see what they did.
I see what they did.
Okay,
I mean,
sure.
and, so like what I'm saying is that like it's off a main road, it's off the highway by like, let's say 1.5 miles off of Route 8. So, I mean, there's other things in there. I want to know what they said. Okay, well, does it have to be on the main highway? Does
Sure.
it have to be,
I get it. Yep,
those
we
are
can-
things that, are going to make it easier for us to come up with a regulation. No, do I want to have a 100,000 square foot thing in the center of Cheshire? No. But if something could go up in the north end and there's a piece of property and they want to build a facility, then that's something that could be, as long as it meets the criterias. Also with the person that spoke, he's already doing this. So it's like, you don't want to, limit him from going forward either. So that's what I'm saying, is that see what the regulation is and adopt it to us.
Understood.
You'd have
You gotta
to
come up to the
podium
mic.
and do your name in that for record.
And I'm not absolutely certain about this, but you're discussing medical marijuana. I believe that the state of Connecticut is only allowing those 4 people to do medical marijuana. I don't think there's going to be more medical marijuana facilities, is what I'm saying. Could there be a recreational facility down the road? Yes. But right now, as it stands, they're not even issuing any licenses for regular cultivators. It's just micro cultivators at this point, because they know that there's going to be about 3 or 4 at least that are going to spend that 10 million, not 10 million, I'm sorry, 3
$3 million.
million, and build a facility in one of those distressed areas. So I don't think there is any more medical marijuana licenses to be given out. They gave them out in 2014 and that's it. So I know you were discussing about medical marijuana and coming in, and I'm not absolutely certain about that, but I'm pretty sure that's the way it is. So.
Mr. Ty?
Yep. So from Attorney Godfrey, what you're saying, I think that in my view, and Sean, correct me on this, for a regulation around the micro cultivator, we brought up about, the adult establishments in town, something similar to that. X number of feet away from, the certain facilities, places where kids gather, et cetera. X number of feet away from a residential area, just to make sure it's, I know that you talked about the fumes or the emissions there, that it would not affect a residential area. And, not that I wanted to, and not that I want it to affect industrial neighbors either. Don't want to say that because I don't, but we have to be really thoughtful about where we would allow it and the effect on the surrounding area.
Well, now you're taking it out and you want to write a regulation at the same time. And that was the question he just asked.
That's what I said in the beginning. Pull it out and have a regulation around it.
Okay. You think we could write something that fast? I mean, come up with something that quick? I mean,
I don't think so. I mean, I
can give us,
that
I
it's-
mean,
Let's talk about it.
okay.
I don't feel that we're gonna be able to write something and
I don't think it's something you can jump in right away
No,
anyway. I mean,
I-
there's
I
a lot of
mean-
legal things that you have to look into. And if you think about it, there's a lot of farmland in Cheshire. And if it's profitable, you can't take it away from them. So if.
You are now.
well,
If this
basically,
moratorium goes into effect.
Yeah, well, we're the way it's laying, but if we do something about it, we can change that, right?
But again,
But
that's
we
why
need to know what we're gonna change before we change it.
So again, that's why recognizing that, that's why I'm saying pull the microcultivator out of the moratorium, but come up with a regulation to govern the microcultivators. If we're pulling it out, just address it with a regulation. Because the point that was asked, if we don't have a regulation there and somebody wants to be a microcultivator and they want to put it next door here, we don't have a regulation in place, they can put it next door.
But they have to get a license.
Assuming they get let's assume that they get the license and they want to put it next to town hall. We have nothing in place saying you can't put it next to town hall. Or you can't put it next to a park, or you can't put it next to a school.
Okay.
That's the only point I'm trying to make there. Do I think that somebody's going to come in and put it next to town hall or next to a school? No, but there's no regulation to say that they can't.
Yeah, there's no regulation at all. So
Can we,
that's why we're gonna do a moratorium. So because there is nothing, and we need to think about what we're gonna do. So, I mean,
But again, Sean, I'm trying to break out that microcultivator. I'm not saying for retail establishments. I'm just talking about the microcultivator, breaking that portion out and coming up with a regulation on where they could put it in town.
so it would be specific to cultivator would be micro cultivator only, not cultivator. That's what you're saying, right? Instead of
I don't know. I
saying,
mean,
because
do we limit it to microcultivator or do we go with cultivator?
I don't know if you could define it as a cultivator is a cultivator. It doesn't matter if you're micro or major or whatever.
Okay, I can buy that. If we're going to regulate where they can put it in town, I can buy into that.
could you, EJ, could we put a very broad regulation, meaning any cannabis business needs a special permit application, and then go in down the road after the state's developed something and go get more detailed into it?
I guess the question would be for staff. If we do come up with some kind of regulation, what to go going forward? I mean, we're gonna have to have a public hearing on the regulation. I mean, this isn't something we're just gonna be able to do in 30 days. I don't know. I envisioned having this 1 year to get together and meet, see what we want to do for the selling of marijuana. I really didn't think cultivator was going to be in there, but I mean, it's not something you could just do overnight. It doesn't help him out very much. I mean, it's going to take at least 2-3 meetings before. First of all, we have to write something. Then we'd have to go through the steps of
And-
putting it into operation.
And as Mr. Cadera said, is that the state still hasn't even defined anything at all, which is, not everything could change. Was it June 1st or whenever they're going to be coming forward? So it's like, in one way, it's like we're doing something that really could be changed in June 1st. So it's like, what are we doing? I mean, if it's, it's like if you're going to decide to do a moratorium, it would have to be until at least September 1st, because you would have to see what happened with the state. And then in July, we would have to figure out some kind of regulation. And then August, we have off. Then September, you would be able to have meetings with public and then go from there. But I mean, like right now, for us to make a decision about any kind of regulation at all, really don't know if it's even right, because we don't know what's going to come forward. And like, as Mr. Kadera said, is that, it's like the state's going to put their own stuff in, and then everything we wrote could be not good.
I understand, but he also made a point saying that we're putting ourselves behind if we do that. And here's a classic example of a cultivator who will be behind because he will not be able to do it.
Behind
apply
on
for
what?
license.
3 businesses? You got 2 people, and what? It's not really what. It's not a financial gain to Cheshire with 3 businesses. It's not. That's not going to break the town in taxes. It's not. That's what I'm saying. Like I don't get why that's so important right now. I don't. I mean, because it's
It is if you're the business.
You can't look at
Well,
that as taxes.
I'm just-
We're not sitting here to decide taxes.
no. I'm just saying is that like it's
Shouldn't
not.
even say it.
It's a business, but I'm just saying is that like we're not capable of giving a good regulation right now on the spot. We need to have more information before we could do that. And I don't know.
Okay, well, there's nothing to be done tonight. I did want to take the cultivator out of it completely, but
Yeah, I mean,
his
it's-
public hearing is going to be held open. We could do a couple more comments tonight. Anyone else in the public wants to speak? But Mr. Kaderis, the floor is yours.
Could as a possibility, come up with instead of or word the moratorium in such a way is that until such time as the state comes out with its final regulations, that we will develop our own regulations if necessary within the next number of days, and doing it from that point, that perspective, almost proactively instead of holding on and just having a flat moratorium.
Sure, you could do it that way. The only thing is trying to define final. There's multiple committees and multiple organizations under the Public Act that are supposed to develop standards and provide them to the governor and the legislature on a rolling basis. Some of those entities, Consumer Protection, Social Equity Council, have done some of their work so far. But, it's just, everything that I've heard only further confirms the need for a moratorium. There's so much uncertainty
I agree.
on the commission,
I agree. I totally agree.
and that was the whole idea back in July.
Yeah.
Was give yourself an opportunity to really study this and not to just knee-jerk spot zone type regulation, but rather come up with regulations based on what concerns you may have and what you may hear from the community. I mean, tonight you had one person that spoke to you, and he's got a pecuniary interest, and that's fine. That's great. We all are in favor of economic development, but it's the Planning and Zoning Commission. We have to write a regulation that is fair and equitable to everybody. And it just seems to me like you need some time to be able to do that. If you wanted to carve out cultivator or micro cultivator, then I don't have skin in the game here. Okay, to me, I'm just trying to advise you the best I can based on what I see in the towns that I represent, and everybody needs to be able to analyze this. There's not one municipality in Connecticut that says, yeah, we've read it, we've got a full set of regulations, we're ready to go. So I think, if you wanted to carve out cultivator or micro cultivator because you feel like, hey, you know what, there's only one license available based on the current statutory scheme. And what we're hearing from the one person that spoke tonight is that he would be at a competitive disadvantage if we waited 12 months to put into place a regulatory scheme for a cultivator or a micro cultivator. Then if you want to carve it out and you want to see if we can come up with a regulation, that's fine. I don't think those two things are inconsistent or need to be joined at the hip from a timing perspective. In other words, you could adopt a moratorium that carves out cultivator, micro cultivator, whatever you decide, and then develop the regulation, whether it takes you a couple of weeks or a month to just develop the regulations for that one category. I don't think you should wait. I would not, you guys had asked me in July what I thought the timing should be. And I said by the end of the year. And then the end of the year, we had COVID. We didn't have the joint meeting with town council. I said, all right, January, because now we know in a couple of weeks, this whole thing kicks off. The application becomes available. There's social equity applicants that get priority under the law. So we understand that. But I wouldn't wait much longer on, if you're going to do any kind of a moratorium, I think at some point you need to just pull the trigger on it. And if you want to carve out a cultivator or micro cultivator and have some kind of a parallel track to develop a reg on that, I think that's a prudent way to do it. But I would not join the two at the hip. In other words, I would not wait to have regulations that you send to a public hearing for a cultivator or a micro cultivator. Meanwhile, there's no moratorium on the sale of marijuana in town.
Are you suggesting to have put a moratorium or vote on a moratorium tonight?
I would do it as soon as possible. If you feel like you need to keep the public hearing open and have more discussion on it,
I didn't. I mean, especially with the fact that we only had one person in here, but from what I hear up here, I'm not gonna make us vote on this thing. I kind of thought we were gonna vote on it tonight.
I'm more about a moratorium right now than I was in the beginning. That's how I feel. Yeah, the reason why I brought up leaving it open was for two reasons. Carving out the cultivator, which, from what you just said, we can address that even if we have a moratorium to pull that back out. And then again, getting public input. I don't know if, we wait until our next meeting if anybody's going to come. Have we received any communications from the public?
No, my office has not.
So maybe I'm on board with Sean there. That we do vote.
Does anyone need to see the public hearing left open? Does anyone take offense if I close the public hearing? No?
Publicized, right?
It was probably, yeah. We had one person speak at it. I've asked 4 or 5 times and nobody wants to speak, so.
Nobody comes, we can't force them.
They care. If we care more than they do, that kind of tells me the public's at.
I mean, I was planning on closing the public hearing and taking action on it tonight. We can discuss in our next meeting whether we want to take action on it. That's up to us, but I'm going to close the public hearing unless anyone has any issue with it. No? One last chance. Anyone from the public? Okay. Public hearing is closed. Moving on to re-subdivision application of Pinnacle Land Development. Thank you, Mr. D'Onofrio, for coming here tonight.
The re-subdivision application of Pinnacle Land Development LLC, care of Phil Bowman, 200 Old Town Road, Cheshire, Connecticut, 06410, for 5 lots, property located on Allen Avenue and Finch Avenue, as generally shown on Assessor's Map number 30, lots numbers 52, 53-1, 53, 152, and 164 in an R40 zone.
Thank you. And representing the applicant tonight?
Good evening, members of the commission. For the record, my name is Kevin Soley. I'm a licensed professional engineer in the state of Connecticut with Soley Engineering. Office is located at 501 Main Street in Monroe. We're here tonight to talk about the re-subdivision at Allen Ave and Finch. So just to orient everyone, here's a map of the existing subject properties, which are at the intersection of Finch Ave and Allen Ave. So the subject site is actually comprised of 5 lots today. these assemblage of lots were actually originally approved in 1994. It's part of the Ferguson subdivision, which actually created 2 rear lots of these 5 parcels. What we're essentially proposing is a re-subdivision to essentially shift these existing lot lines to better allocate the overall space of the overall property and to create or to provide for 3 building lots to construct 3 new homes as shown on the proposed plans in front of you. So we're proposing to have a direct access off of Allen Ave to feed, to create a rear access drive to access a proposed lot on Lot 2, which is located here, and then to construct 2 new homes on Lots 3 and Lot 4, which would be accessed off that rear access way. There's an existing home on Lot 1 shown here, which will be demolished as part of this application and then reconstructed with a slightly different footprint. The existing home, which is shown on Lot 5, is actually, it exists today. That is accessed through a driveway onto Finch Ave, and access for all other properties will be proposed off of Allen Ave. This site has received in the Wetlands Commission approval. I think we've been able to address and satisfy all the comments from the fire department, the police department. I believe there's a staff report in the file which essentially shows that we've been able to satisfy all the concerns. There's some conditions that we're very happy to accept. What I wanted to do was kind of give you all a broad overview, and I'm going to pass it off to one of my associates, Chris Pulowski, who's going to run you through some of the technical details of the application, and then we'll be here to answer any questions that the commission may have. Thank you very much.
Good evening, Commissioners. My name is Chris Pulowski. I'm a civil engineer with Solely Engineering. Office is located in Monroe. Tonight before you, we have a proposed 5-lot re-subdivision. As Kevin mentioned, 3 of the proposed lots will be served off a 15-foot wide rear accessway coming off Allen Avenue. This will be 15 feet wide with 6-foot gravel clear zones on each side. There will also be, some of the areas are going to be 3 feet due to a drainage swale. We couldn't provide the full 6 feet throughout the entire, both sides of the rear access way. And we are also providing, we've been working back and forth with the fire marshal's office. We are also adding 2 proposed pull-off spaces that are 6 by 35 with turf reinforcement. And that'll be used to provide emergency vehicle parking in the event of any emergency. And again, we have been working back and forth with the fire marshal's office, and we have received their sign off. That letter should be in your packet. So those are 3 existing lots off of Allen Avenue here. That's lots 2, 3, and 4, as Kevin alluded to. Lot 1 is currently 940 Allen Avenue. That is an existing residence that is going to be torn down. The existing driveway will be repurposed and reused to access a new home, which will be built on this lot. And then again, lot 5 is the existing residence that is served off of Finch Avenue. Nothing is going to be disturbed on this lot. It's going to remain exactly how it is and move forward. So the homes are going to be between 2,000 to 3,000 square feet footprints. The layouts are shown here. We did extensive testing with Chestercott back in August. And we did lay out 4 new septic systems, 1 for each of the 4 new residences. That's, again, those are lots 1, 2, 3, and 4. The existing residences to remain the same. So 3 of the lots 2, 3, and 4, will be served by well. There will be new wells drilled and installed. The residents at lot 1 will reuse its existing water lateral that comes off of Finch. The nearest water service is 750 feet away. We did look into that, but it's quite the distance there to extend it. So all the drainage on site, if you look here, lots 1, 3, and 4, there's a ridge that kind of runs currently. This all drains off to the east and the north. There are significant wetlands. The entire site is about 17 and a quarter acre, a little plus or minus. There's over 4 acres of wetlands on the site. We did receive wetlands approval as we're just barely disturbing the upland review area. But a lot of that water currently drains to the north and to the east. There is an intermittent water course that runs through the property here, and all the water then flows down and away off the property. So in order to treat and slow down this water, we are proposing a stormwater water quality pond that's located on Lot 2. There is 2 easements on the property that are being proposed. One will be the access easement for lots 3 and 4, 2, 3, and 4 to access their property. And there will also be a stormwater maintenance agreement or easement as well, so that the pond can be maintained or the maintenance can be shared by all of the proposed lots. So as part of the engineering comments, and again, the stormwater was designed in accordance with the 2004 Connecticut Stormwater Quality Manual. I did want to say that. And then when we were going through the engineering comments, one of the comments was that the right-of-way has to be 15 feet wide. These lots are pretty old. So along Finch Avenue here, the edge of the curb is like right off the property line. So we will be deeding approximately 12 to 15 feet in this area. It's shown in a hatch to the town of Cheshire to establish a right-of-way. If they want to come, if you want to come in the future and widen the road, improve the drainage, whatever needs to get done, they have the right to do that, and they have the full right-of-way width as required by the subdivision regulations. So again, that is to be deeded to meet that requirement. Throughout the site, we have a number of soil erosion and sediment control measures. We have an anti-tracking pad construction entrance. We have silt fence. We have silt fence with hay bale backing at the outlets of the stormwater basin. We also have erosion control blankets on 2-to-1 or 3-to-1 or any slopes greater than 3-to-1, excuse me. So when you pull out of the rear access drive here, we wanted to make sure we had enough sight distance in both directions. So we are cutting back. There is a hill currently on lot 1. So we are cutting that back at a 2.5-to-1 slope. This will be stabilized with an erosion control blanket and then seeded and established. We are cutting back that hill so that you can look left when you are coming out of that rear access way and you have the required sight distance as required by your regulations. So that pretty much sums everything up. Again, there are 5 existing lots here. 4 will become new homes. 3 will be served by a proposed rear access way. 1 will maintain the existing drive. There are various grading and stormwater features that we'll be using, but the stormwater quality pond will treat and reduce all peak flows going off the site. And of course, we have the silt fence, anti-tracking pad, the hay bale backing, and the erosion control blankets, as well as the silt sacks and sediment traps for soil erosion and sediment control measures. And with that, unless Kevin has anything else to add, I will open it up to the floor. If any of you guys have any questions, I'd be happy to answer them.
So the existing rear lot is there, and that's been approved. That's why we don't have a rear lot, whatever. And the other 2 lots have frontage on Finch. Is that how? Yeah. And the common drive is.
That's correct.
That's okay.
Just touch the base.
Sorry, yep, that's correct. So in 94, its subdivision was approved,
Yeah.
created 2 rear lots, one off of Allen, one off of Finch. There was a note on the subdivision that basically what we're doing here is legalizing that the reconfiguration of the lot lines. So the note was said that the rear lot off of Allen was not considered a building lot, but they still yet the commission still created a second rear lot off from Allen, and you have one off Finch, which that's if on the map you can't see the one on Finch because they have the existing home is white. Could you go back maybe to the previous map?
Yeah, so this is the existing layout. So again, there are currently 5 lots. These were approved as rear lots back in 1994, I believe. I'd also like to point out that we are widening the frontage. That'll be the new lot 2 in this area. So it will no longer be a rear lot. It will have the minimum lot frontage. So it does not meet the definition of a rear lot. But again, back in 1994, both of these were approved as rear lots.
Where is that lot frontage?
Which lot? Lot 2?
The one you just mentioned. It said you're changing the lines to give it the frontage.
This existing rear lot that was approved in So the existing rear lot, which was tax lot 30-152, which is our lot 2 on our plans. This had it was approved as a rear lot in 1994. It had 49.85 feet of frontage. As part of our re-subdivision plan, we're actually expanding that to provide the full 50 foot to meet the minimum frontage requirements. But as it was already pre-approved as a rear lot, we believe that has been already approved. So we're simply, making some modifications. Again, this shows the best, I think, the existing parcel configuration. And then what we're proposing from a re-subdivision standpoint is essentially just to kind of pull some of this area, dedicate this to this lot off of Allen, and then essentially reconfigure the lot lines which have frontage on Finch to provide them with access
That was
to
my
the
question. That's why
rear
those
access
lots 3 and 4 are not considered rear lots because
That's
they have
correct.
frontage on Finch
That's
Avenue.
that's correct.
That was my question.
Yep.
Sorry.
It's just a,
Mr. Tedesco. Oh, I can't see with these masks.
yeah, I was just gonna say, I had kind of the same question. So lot 3 and 4 are basically L-shaped, or becoming L-shaped is what you're proposing. And I see a dashed line here, but I'm assuming that's the old lot line. And the new one it's 2 houses coming out with frontage like that.
Yeah, that is correct. So lots 3 will be an L going this way. That'll have frontage on both Allen and Finch. And then lot 4 is an L going the other way. That will have all of its frontage on
So
Finch Ave.
the houses are all close together, but the land is all around it, basically.
That is correct.
Okay, thank you.
Thank you.
Mr. Tedesco.
Well, Michael, so if there was an approval in 1994, we're saying it, is that still effective today?
That's correct.
Okay, so, and there was one or two rear lots that were approved in 1984?
Two rear lots.
And has the configuration of those lots changed at all from the approval in 1994 to what we have today?
Other than the modification that Mr. Solly mentioned before, no. Prior to this application, nothing's changed to the meets and bounds of those lots. But tonight, in their application, yes, they are modifying the property lines.
Okay, so, and so are we dealing with different lots then? I mean, if we had particular lots approved in 1994, and we had the exact same configuration today, you're telling me that the approval still applies and we move on from there. But if, in fact, the configuration of the lot lines have changed, what does that do to the approval, if any?
So, I mean, the approval for example, the 9-acre parcel, which has frontage on Allen Street. If you want to go, could you go back to the previous map, the yellow that's on this map that's shown here? That stands today. That's a lot.
And is that a rear lot?
That's a rear lot. And then the one that would be the darker color, is that a black? It's
Purple.
Purple, I'm sorry. So that was the other lot that was approved in the 94 subdivision application, which is also, it has an access, it's a rear lot. That goes out to Finch.
Okay, those lots are essentially the same today as in 1994.
Correct.
So okay,
And
so
the
what
only-
changed?
Yep. The only other substantive change is what the applicant mentioned around the right-of-way, which under Connecticut General State Statute, that's another trigger for a re-subdivision if you're modifying a street line that was associated with the subdivision. So they're deeding portions along Finch and Allen in order to accommodate right-of-way, more area for the right-of-way to be expanded, et cetera, or physical improvements to area that was reserved for public use. So it's like a twofold sort of thing that's going on.
All right, so is part of this application tonight still, is it under 5.5 for rear lots, or is that, it is?
Because you have a driveway that's a rear lot, we applied those standards for the reasons of in discussions with the fire marshal's office. One was just the public safety issue, being able to access the rear, having apparatus to be able to pull off, or oncoming traffic to pull off to the side, so the apparatus can safely get to the one of the houses back there. And then the other was, the reason why, as Chris alluded earlier, with the layout, they weren't able to provide the full 6 feet of gravel shoulder due to topography. So that was review one that was an acceptable design with the turf reinforcement blocks was proposed and approved by the fire marshal's office. So we held them to those standards just because you have now a home that's going in the back there that really needs to have a safe access in and out for fire, et cetera.
And the fire marshal has accepted that as being safe access?
Yes.
Still, with respect to 5.5, I mean, we talk about this regulation all the time, and it's got specific requirements in it, which I normally don't hear about unless I ask about them. But what the regulation says is that rear lots may be permitted by the Planning and Zoning Commission, subject to obtaining a special permit, as provided in section 40. The approval shall not be granted unless the commission finds that the land characteristics and physical site locations make the creation of rear lots practical and desirable, first of all, and only if the commission determines that there's no logical or feasible alternative for the lots to be properly served by an accepted town road, street, or highway at the present time or in the foreseeable future. So, I mean, it seems to me that we should hear something about those requirements tonight before we approve this.
Sure. We can certainly,
Well, I think it's required, it's not just
sure. So,
optional.
yep. So we're the lots that were as part of this re-subdivision and the reconfiguration of these lot lines, lots 3 and 4, which have access or which have frontage off of Finch Ave and Allen Ave aren't rear lots. We're not proposing to create rear lots. We're simply proposing to provide access to those lots through a rear access way, which will be established on lot 2, and that's really to protect against and to minimize, disruption or disturbance of natural resources and wetlands, because those 2 lots do have wetlands that would basically bisect and separate the developable area from Allen Ave. So rather than trying to provide that direct connection directly to Allen, which those properties have frontage on, we were simply proposing to access those pieces from that rear access way to minimize that impact to the natural resources.
Okay, so those lots could have, they don't have to be rear lots, but it's better because for protection of various natural resource.
Correct. Yes, that's correct. So they're technically not rear lots, so they don't meet that criteria of needing a special permit. But we're providing the access through that rear access way simply to avoid that impact to those wetlands, those natural resources on the property.
Okay, so that's what makes the rear lot access way desirable, I guess, under the regulation.
Correct.
And it seems obvious from looking at it, but I still think we should have you tell us this, that in fact, that there's no logical or feasible alternative for these particular lots that are being served by the access way to be properly served by an accepted town road.
Yes, that's correct. And just to summarize what I just mentioned, yes, we could provide direct access driveways to those lots from the town road on Allen Ave. However, that would require direct wetland impacts.
Right, but you couldn't serve those lots by a town road.
Oh, correct. That's, again, if we were to propose a town road, we would still have that same impact to the natural resources, which we're trying to avoid. And when we first started to look at this, we wanted to see how we could, utilize these 5 lots that are here, but do so in a way that doesn't have adverse impact to the wetlands or the resources, or require any additional town roads or things like that. So what I think what we've been able to come up with providing access through this rear access way on lot 2, it ensures that there isn't, additional maintenance obligations on behalf of the town by creating a formal subdivision road. That can be managed and maintained privately by the owners of these 3 lots. And I think in response to the planner's comments, we're adding that, notations on the plans so that there is no adverse impact to the town of Cheshire or maintenance obligations associated with that access way.
All right, thank you.
Even though they're not rear lots, it's things like the garbage collection and all that stuff is still, they know they have to go to the end of the street, right? It's just a little weird that they're not rear lots, but they're using the rear lot access way. That's the confusing part for me. But they're not asking for a rear lot because the one lot already has the rear lot, right?
That's correct.
But the same stipulations are still in effect?
Well, we wanted to design it in accordance with those standards because those standards are obviously well-founded and established. So we wanted to make sure that what we were proposing, even though it didn't meet the technical requirements of a rear lot, we wanted to make sure those standards were established and provided.
Okay, I mean, it works with staff?
It worked, yeah. I mean, it was, like I said earlier, it's a safe access in and out. It has been reviewed internally. The other thing is just the limits of disturbance along the proposed driveway. Kind of to go back on Lou's comment about what does a public road look like? That's significant disturbance of earth because they're going to be chasing grades in order to fulfill appropriate right of way. This accommodates stormwater. You're not grading right up to the property line and leaving cuts that are to be significant. This is like the least disturbance, and it plays into the other issue with the sensitive environmental receptors that are also on the property, where you're limited having driveways going out to Finch by sharing the driveway. You have a reasonable design driveway that has safe turnoffs that are required in your rear lot regulations. It's responsible management of stormwater, and grading is kept to a minimum in order to achieve that.
I have no issue with using the road to do that. I'm just saying it's not really a rear lot. They're not really rear lots, but they're still going to follow the rear lot
They're still following it.
application.
They went above.
I
They
mean,
went above.
they have
and
to
beyond.
work together with the plowing, the
Yep.
garbage, and all.
Yep.
Everything
That's
is going to be, as long as it's all right with staff, I'm okay with it. I mean, it's just confusing. But
Well, I think what we're hearing too is that, I mean, a town road requires a significant more displacement of the area than a rear lot.
correct.
And here would be pretty short anyhow, wouldn't it? We're not talking about it. How long is the rear lot actually?
Approximately 420 feet.
Okay, that'd be a very short road. And therefore, a town road is not feasible or logical for here in this. And I think that's a subordinate finding that we have to make, which based on that testimony now, I think we can.
But it's not a rear lot access, so that's why you don't even have to make that finding. That's the confusing part.
Well,
They're not asking for rear lots.
Correct.
well,
That's why I'm confused. Like, they don't have to. They're just saying they're using the one existing rear lot. They're using the driveway, but they're not really rear lots.
Well, I understand your point, except the application is brought under section 5.5 also. And it seems to me if you're treating it as a rear lot functionally, you have to meet the requirements, which they've done.
Correct.
I don't know if we need to quibble over that, but that's, I understand what you're saying, Earl, but it seems to me if they brought it under 5.5, that they have to meet those technical requirements. They're not technical, they're really substantive requirements, but they've done that.
It's certainly a little unique. We understand that it's, we probably should have taken maybe some more time to kind of walk you through it to start, but, we tried to create something that was, met all the requirements, exceeded those requirements, really.
Gotcha. Anyone from the public wishing to speak on this? No? Commission members, any other questions? All set? Okay, I'm going to close this public hearing. Thanks.
Thank you.
Entertain a motion to adjourn the public hearing. Moved by Mr. Kaderis, seconded by Mr. Strollo. All those in favor signify by saying aye. Moving on. I'd like to call to order the regular meeting for Monday, January 24th, 2022. Can I get a motion to accept the minutes from our public hearing and special meeting from, so
just want to change the minutes. I was not here, so.
I was not also.
you're both going to recuse yourself from the vote, right?
Yes, but we're on the minutes. It says-
Oh, it's, let's
Says that we-
let's bring it forward first.
Motion to approve.
Motion by Mr. Natale, seconded by Mr. Strollo. Now, in the minutes, it said you were here
Yeah.
and you were not, and same with Ms. Downs?
Okay.
Okay. So with that change, Marilyn's not here, but with that change, is there any other changes or discussion for the minutes? All
Motion
those
to
in
accept as
favor?
opposed.
I'm sorry, go
Motion to
ahead.
accept as modified.
We have the motion already.
All right.
Oh, modified, do you accept that?
Yes.
Mr. Strollo accepts it. All those in favor of the motion signify by saying aye.
Aye.
Anyone opposed? And anyone recused? 2, so the motion carries 7-0-2. Communications, we have a letter from Arnett Talbot.
So you have a letter from Arnett Talbot, just a follow-up on Public Act 2129, opt-out. Town council voted unanimous to opt out. So we are done with that, at least the first portion. Then obviously, we should probably look at the accessory dwelling unit regulations next. But so that opt-out is effective. But we have until January 1st, 2023 to, if you choose to adopt new regulations for the accessory dwelling units.
Going forward, a question on that, like, would we want to bring up one of our zoning meetings or well, not really a subdivision meeting, but maybe a zoning meeting in 209 where we're not doing it up here?
You could do a workshop. Basically, you want to have a workshop for that. I would recommend doing that.
For that
approach
and
for that
probably the
particular-
cannabis.
And also, yes, the cultivator issue, the cultivator, micro cultivator. I think those are two appropriate uses of the workshop option. So maybe under your, I think you have the POCD subcommittee.
Or we could do POC.
You could do it under that.
One of the
'cause-
two. Okay. We'll work on that to schedule on something.
Okay.
Number 2, we have a letter from Anthony Pizzone.
Yeah, he's looking to name, this is the Coleman Road subdivision, the Michael Place. We looked at the name, it meets the list, it's not a repeat of another public road in town, nor does it sound similar to another one, so it's
Do-
okay.
Do we have a motion for that?
Bidding for your first road, huh?
Don't, I have to call him about that, thanks.
Do we have a motion to approve that, or is that something we should
You could just motion to approve the motion, you just have a
Just make a
simple,
motion?
simple motion to approve.
Anybody want to make a motion to,
Second.
okay, motion by Mr. Strollo, seconded by Mr. Natale. Any discussion on Michael's Place being named the road? That's a nice gesture. Michael Tribadino was the owner of the farm there, so I understand the reason for Michael's Place. So all those in favor of the motion signify by saying aye. Aye. Anyone opposed? Anyone abstaining? Motion carries unanimous. Unfinished business, 1, 2, 3, 4. Okay, number 5. Does anyone have any issue with taking up number 5 tonight? That we just heard, Pinnacle Land Development?
Just, the other ones are tabled. 214 is actually now 216, correct?
Yes, if everybody saw we changed from Valentine's Day, we figured we could all go with our significant others if we had plans, not only us, but also the public might have plans also. So we checked the meeting dates, and I believe this room is available, right? And for Wednesday, so we're ahead of the public, whatchamacallit that you put out. I can't, the notice that you put out. So we changed it to the 16th. So everything, yes, will be heard on the 16th, not on the 14th. So do we have a motion for number 5?
You do, Mr. Chairman. So a motion to approve application of Pinnacle Land Development applicant Phil Bowman, Arnold Wilhite Jr., James Wilhite, Donna Tim, and Janet Wilhite owners, application for a 5-lot re-subdivision of the properties located at 940 Allen Avenue, 365 through 375 Finch Avenue, Zone R40. The Cheshire Planning and Zoning Commission has found the proposal to create 5 residential building lots as shown on plans entitled Proposed Subdivision 940 Allen Avenue and 365 through 375 Finch Avenue, Cheshire, Connecticut, revised through January 14th, 2022, prepared by Solely Engineering, are consistent with the requirements set forth within the Cheshire subdivision and zoning regulations, and hereby approve the application subject to the following conditions. 1, limits of clearing for the driveway and stormwater basin. It says lot 1, it should be lot 2, are to be marked by a licensed surveyor in the field prior to start of site work. Said limits are to be reviewed and approved by the zoning enforcement officer. 2, to satisfy the town of Cheshire subdivision regulations 5.5B 13, a professional engineer will need to certify that the rear lot was built to design on sheet 2.10 as revised through January 14th, 2022, prior to certificate of occupancy to be being issued.
Move staff wording.
Mr. Dawson,
Second.
second by Mr. Natale. Any discussion on this motion?
Yeah.
Mr. Tedesco?
This was actually very interesting. I thought that the gentleman gave a nice presentation on this. It was helpful. Do we need to incorporate anything from the fire marshal on this? Does that need to be incorporated?
That's condition number 2 from the fire marshal. To satisfy, that's the requirement of the certification of the engineer for issuance of certificate of occupancy.
Okay, thank you. Nothing else.
Any other discussion on the motion? All those in favor of the motion signify by saying aye. Aye. Anyone opposed? Anyone abstaining? Motion carries unanimously. Okay, number 6, the CTEC solar. Oh, the guys are here, okay. Yeah, you can take that. That's fine.
Good evening. Good evening, esteemed members of the PNZC. My name is Jin Tao with All Point Technology, here representing CTEC Solar on their application for a solar farm at the 5 McKee Place, which is a Hanwha aerospace facility. So this project has already been brought in front of the IWWC, and we have an approval with conditions from them as of last year. The letter we got in December 2021. So to give you a quick rundown, because you guys have done an amazing job so far tonight tackling with some of these new progressive rules and regulations that are being trying to figure out. And I think it's the commentary that I heard tonight was great. The questions were great. Working as a engineer for developers in new energy, such as solar, it's always been kind of difficult working with towns that don't have regulations. And I have very much enjoyed working with your town staff, and they've definitely helped me a lot in figuring out a path forward for this project, especially with permitting in the town PNZC. So the applicant CTEC Solar is interested in developing a 1 megawatt DC solar facility at the Hanwha Aerospace Manufacturing Facility. It's going to be located due east of the existing facility where there's existing grass, turf field. And the 1 megawatt DC translates to just under 1 megawatt AC, which is why we're presenting this to the local council instead of the siting council, the state. As such, this solar facility is going to actually be a ground mount racking tracker system. So that actually facilitates, you can see in the way that it's laid out north-south versus typically east-west for just static ground mount solar panels. And those trackers will follow the sun in the direction throughout the day. With that, the energy generated from the solar facility is intended to serve the manufacturing facility itself. And the client is also interested in installing a battery system. The battery system will be located just north of the building, near the parking lots. And the final design of that battery system is still in flux. But the space that I've seen in comparison to another one that I just recently did with this client, the battery system ended up having a lot less square footage impact compared to what we're currently showing on the plans. In terms of the site does have, the existing site has wetlands to the south and southeast of the existing building. It's one wetland system with kind of like a roadside swale that has been classified as a wetland that further feeds into it. And then there's a pond that is actually on the other side of McKee Place that also feeds into this wetland system as well. Per the IWWC, they were very interested in kind of the buffers that we were holding. Overall, the entire facility will be maintained outside of any regulatory buffers. And the only direct impact will be selective tree clearing, which they have, the IWC has approved with conditions of if we are within the buffer to the more robust system to the direct south, that we are going to be using hand methods instead of heavy machinery. So again, I know this has been a long evening, so I'd be happy to give you more detail or just answer some questions.
Just to start, there's like fire department comments and engineering comments. Have they all been addressed?
Yeah, so I'll speak to the fire first. Fire, yes. The one thing that the first important things the fire marshal would like is that there's a water line that runs through where this proposed ground solar farm will be located. They would like it relocated closer to the building, and ironically, it used to be close to the building, so they're going back to the old location. The other is just safety procedures on shutoff, and the installer needs to provide disconnect information, and where the method of securing power will be approved by the fire chief, which is something through the building permit process. They can work that out with fire. Engineering was, the concern was having the proper seed mix to apply. In my experience, I permitted a larger solar field in Simsbury. We went through the solar farm, the siting council. It's a smaller scale. they're not disturbing the earth when they put the panels in. The way it works is they're there, and maybe the applicant could speak to the installation process. It shouldn't be an issue, and if they do have any areas of exposed earth, those can be addressed by the proper seed mix. Make sure it's on. You're on.
Yes, that's actually accurate. So currently, the site is actually relatively flat, and that existing turf area is turf. So for the installation of the ground mount racking system itself, actually no grading is actually proposed on this site. The site is very conducive for the installation of this racking system. And then to kind of address the concerns from a state level and other development level of solar ground mount systems, the applicant is planning on using a specific solar farm seed mix, which is designed to grow up to about a 3-foot maximum height. And it's supposed to be a low maintenance seed mix. This seed mix actually functions better than just a grass turf in terms of reducing stormwater runoff compared to its existing condition, as well as it reduces the amount of maintenance needed out on site. I think typically this seed mix requires like 1 or 2 mowings every year. And so like overall, the mix between the use of this seed mix will decrease the amount of stormwater runoff and provide more stability for the fenced-in area of the solar field.
So yes, to answer your question, the chair, those comments have been addressed. Or in the case of the 2 comments for the power shut off with the fire marshal, that will be addressed through the building permit process.
Okay.
Thank you.
Mr. Kaderis?
Will the solar farm be generating excess energy than would be needed?
I can't say for certain how much, if that is actually going to be true or not, but with the installation of the battery system as well, I think the plan is to use and be able to store some of the excess depending on when the manufacturing facility is in need of that peak power.
Would you be selling any of it back to the electric company?
I don't think that is the current plan.
Mr. Tedesco?
So the solar panels are going to supply all the electricity that this factory facility needs to operate?
Most likely not. It's just to supplement their energy uses.
I'm just curious, it has nothing to do with approval. How much of the overall needs of the factory might it offer?
That is a great question. As I'm not the electrical engineer, I actually don't have an answer for that, but I will definitely reach back out to Devin.
It's not a condition, it's just, I mean, it seems like a wonderful, wonderful thing.
Yes, yes.
Yeah. All right, thank you.
Any other commission members? Questions? No? Okay. Did you do a motion for this?
I do have a motion for this.
Is everyone comfortable with a motion on this tonight? Yeah, okay. Can we hear the motion, please?
So it's a motion to approve application C-Tech Solar LLC applicant, Hanwha Aerospace USA owners, application for site plan for the addition of ground-mounted solar panels, generate power in support of existing manufacturing facility. The Cheshire Planning and Zoning Commission finds that the site plan application as shown on plans entitled Cheshire Solar, revised through December 23rd, 2021, prepared by All Points Technology Corporation, are consistent with the requirements set forth in the Cheshire zoning regulations.
Move Mr. Kaderis, second by Mr. Strollo. Any discussion on this motion? Seems like a great thing. Hopefully it works out. All those in favor of the motion signify by saying aye.
Aye.
Anyone opposed? Anyone abstaining? Motion carries unanimously. Thank you.
Thank you.
Thank you.
Okay, number 7, our proposed amendment. What does everybody feel? What would anyone like to do tonight? I mean, if we do it tonight, I'd like to see the cultivating part taken out. I don't know. Anybody want to change my mind, convince me? And
I'll be voting against it as written, as is.
What did you say, Mr. Kadesh?
I'll be opposing the moratorium
as written.
So from what we heard from the town attorney, he did recommend approving as is and then using the POCD meeting or one of those other meetings to address the cultivator, correct?
That's correct. Well, we also gave you the ability, if you want to take cultivator and micro cultivator out of the moratorium, you have that authority.
And the only risk there is,
The risk is right now it sounds like you have one person that's going to apply for the license.
And there's nothing that says we can't get going on a POCD meeting to start the process for anything. I mean, to start a regulation process for.
Right. I mean, we'll, as staff, we'll pull the regulations from Watertown. I also know, and sorry to keep saying my former town, they had regulations too in Simsbury and have a medical marijuana production facility there. So I can get those easily for the commission. We'll have at least 2 communities that have regulations in place. But that just starts the conversation on regulations. So you really, it's a commission decision. Do you want to keep cultivators in the moratorium, or do you want to take cultivators and micro cultivators out of a moratorium if you're going to vote for the moratorium? I think that's really what you have in front of you right now.
I would like to see it taken out, the micro cultivators and micro cultivators.
I think I could vote in favor of taking it out as long as we have a commitment of the time frame to address it, to come up with regulations.
And that could be something we could set, for soon, to at least start the process.
Because I know that, I mean, when we talked about these regulations, like our attorney said, we started talking about this back in June or July. So I don't want to wait another 6 or 7 months to address that.
Yeah, I mean, even if we just got together and started talking about the cultivating part and what we wanted to hear.
Oh yeah,
At least
that's what I'm saying. Yeah, I don't want to wait 6 or 7 months to address the cultivator part if we agree to pull it out.
I think maybe when we get together and have a subcommittee meeting, the first thing we should probably do is look at the other communities, how are they regulating it, and 2, what's the commission's, how do you feel geographically where it's appropriate to have these uses, and then the last thing that you'd have to look at is, are there any sort of separation distances you want to talk about, or how do you want to regulate it? Do you want to have it as of right? Do you want to have it special permit, site plan? Those are really like the outstanding items that you need to address, and really we shouldn't be doing it on the fly. I think using the committee process for this particular regulation is appropriate, and that could be accomplished in 40 between 30 and 45 days.
Yeah, of course.
If we approved it as is, could we then go back and hold the cultivators and so in other words, we're approving as is, we're giving ourselves the leeway once we do our investigation and our research into what other towns are doing, et cetera, and then carve the cultivator, micro cultivator out and address it?
So you have that ability too. You can approve the entire moratorium as presented. And then let's just say in 30 days, we come up with a regulation and we propose a text amendment along with modifying the moratorium to remove cultivators and micro cultivators out of the moratorium.
See, my only concern is that I want to be in a position where we're reacting as opposed to responding. And the motivations in both of those situations are very different. So if we have an opportunity to take a step back, be thoughtful about our approach and not feel this pressure breathing down our necks. Again, it doesn't mean that we kind of sit back on the world. I don't think anybody's suggesting that. But by the same token, I always prefer to respond versus react. And I think approving as is with a commitment to investigate this with all of the discussion that's taking place, maybe does an option.
Is that a motion to make?
If I may, Mr. Dunn.
Yeah, you have the right.
It's not a motion. That's not a motion. We have a motion.
So
if we're
I
gonna
would
hear
say
it.
you have a motion that was this was
Woody, she's
developed
actually
by.
not even sitting right now to put a motion up.
You have a motion that was developed by the town's attorney. If you want, do you want to read that in the record first, maybe? Resolved, whereas the Connecticut Public Act 21-01 entitled An Act Concerning Responsible and Equitable Regulation of Adult Use Cannabis, which legalizes cultivation, processing, distribution, possession, and use of cannabis, marijuana for recreational purposes, was signed into law on June 22nd, 2021. It became effective July 1st, 2021. And whereas the law is lengthy and complex and raises novel legal, planning, public safety issues, and requires that the Cheshire Planning and Zoning Commission study and assess the potential impacts of the law on the town of Cheshire, the need for potential regulations on cannabis establishments as defined by Public Act 21-1 in a thoughtful and responsible manner, and to undertake a planning process to consider amending the zoning regulations regarding the regulations of such establishments. And whereas a moratorium will allow the Planning and Zoning Commission sufficient time to undertake the required assessment and planning process, including the receipt and analysis of input from town officials, residents, and property owners and others. Now and therefore be resolved, the Planning and Zoning Commission shall not accept, consider, or approve any applications, hereby prohibits the issuance of any zoning permits to permit cannabis establishments in any zoning district in the town of Cheshire for a period of 12 months effective January 24th, 2022.
Move, Mr. Natale. Second. Second by Mr. Strollo. Okay, discussion on the motion.
I think what Anita said made a lot of sense. If we approve it as is, we still have the ability to do what we've talked about within 30, 45 days and address the right way to do the cultivator.
Question for staff. If we do write something in 30 to 35 days, and we actually have to go through the public hearing, that process and all that stuff.
That's correct. So you're probably looking at, let's say, between 60 and 90 days to enact a regulation. Assuming you were to draft something, the commission agrees upon it within, let's say, 30 days, the max, 45.
And as far as changing and taking cultivating out of the moratorium, can happen at any time, or is it something that would have to?
If you pass the moratorium as proposed, in order to modify it, you'd have to go through a public hearing process. You can't just tomorrow say, okay, this is out. So I guess the comment would be is tonight, either you pass everything or you exclude cultivators and micro cultivators from the moratorium.
I'm kind of torn.
I'd be in favor of excluding cultivators and micro cultivators.
Either way, it gets us to the same place, but leaving it in gives us some type of protection because we have a regulation versus not having anything in place.
They won't even have a license. Theoretically, we'll have the regulation done by the time they're issuing a license.
To me, we heard a Cheshire business that wants to apply for something tonight, or that he said tonight that is happening in the near future. That now he can't apply for that.
It's risky.
License.
It's even riskier if he applies for it.
He's not the only guy that could do that. Somebody else could do it in town too.
He's the only one we know about.
Yeah, I know.
But the question
But-
is his risk. We are impacting his risk.
Yes,
We're giving him his risk. That's the risk. It's us.
I was more concerned about the sale. I thought this was more the sale of the marijuana or the cannabis or whatever we want to call it, and that's what I thought we were putting regulations in to sort of protect us the way that we would want Cheshire to be protected. To me, the growing of it has its own regulations now. He's not selling it. He's not. If he's correct about the 10,000 square foot greenhouse, I mean, it's a minimal thing. I don't know. I just take exception to the fact that we're causing a problem to a Cheshire business that wants to move forward into the future. That's I don't know. That's why I don't like leaving it in there.
Can you just take out number 7 of the, if you're accepting the proposed amendment minus number 7?
Those are just definitions.
It's not part of the, oh, okay, you're right, yep.
With-
yep.
To Ms. Down's point, you just put, and Michael, correct me if I'm wrong, but you just, at the end, now therefore be it resolved, et cetera, et cetera, et cetera, to permit cannabis establishments except for micro cultivators and cultivators. Those are legally defined in statute.
And then I would, to Ms. Down's point, delete those those 2 definitions if you're going to exempt them from the moratorium. So in the motion, say you're going to have an exception, and also delete them from, basically tying the loop. I don't want to loose ends on it. If you're gonna take it out, let's take it out both ways.
Okay, I'm just suggesting it. I mean, I'm not trying to change anything that has to be accepted by the maker and the seconder, but I didn't see that being an issue. To me, it's not an issue. I don't know how anyone else feels, but
So could I just maybe make one comment, just food for thought for the commission, is that the way that the recreational marijuana is written, if you take it out, let's just say in the lottery opens up, it means that you have to treat it, if you don't have regulations in place or a moratorium in place to say, hold on, we're going to take a pause. That use can land anywhere in town where a similar use is located. So if you allow agriculture or that type of operation in any residential zoning district, I mean, he's in an industrial zone. So I think, remember, just in the back of your mind, remember that if you're okay with it landing anywhere in town, then, you don't have to worry about anything if you take it out and you want to develop regulations in the interim. But you just need to that should be in the back of your mind. If someone else were to say, like we've kind of alluded to, I'm going to put in for the lottery, and they could be next door to town hall, and they want to open a cultivator operation or a micro cultivator operation. If that's out, we have to treat it like a similar use. That's what's in the state law. And that's why a lot of towns are putting these moratoriums in place, is that it's just to put a pause to kind of really assess and say, hold on a second, where is these uses compatible in town, and how do we want to regulate them if we want to allow them? So I'm not trying to advocate one way or another. I want to show you the other side of the coin and what you should consider if you take it out. That's my warning, to say you run that risk that someone else could come through the door. And then we really can't say no to that other person. But, to the chair's point, you also, not to talk on both sides of the aisle on this, you also have someone who's came in here saying, listen, my business, I want to expand. The services are offered. If you implement this, I can't expand.
Under the first rationale, we don't know about it because nobody else showed up tonight. Cheshire Nursery, they have greenhouses. If we take it out, somebody comes in, buys Cheshire Nursery, or Cheshire Nursery wants to put it there, we can't stop them.
That's correct.
And that's right with neighbors, houses, the smell, everything else.
That's correct. Because the way that law is written, if you don't have regulations in place, and these applications, the process opens up, you have to treat it just like the retail use is the same thing. Anywhere you allow retail, a retail cannabis facility can open up, and you have to treat it like any other retail use. So if it's as of right or permitted by a site plan, that's how it gets approved. And the town can't say, No. This isn't the location I wanted. I wanted it over this end of town. You can't, if you don't have those safeguards in place, you've lost control of that. You've lost the influence on the locating abilities.
But as it is right now, every house in Cheshire with 2 or more residents in it can have 6 marijuana plants.
That's correct too.
And also medical growers could pop up anywhere right now too. Regardless of the licensing issues, but if they
Yeah,
open more licenses,
If the licenses were increased, yes, they could,
they could put it across the street. Medical.
Can we have two motions? Can we take the cultivator out of our original motion and then vote on it? And
Yeah.
then vote on putting a moratorium on cultivating?
That sounds appropriate.
That way we get what we're accomplished here tonight and see what happens on the second vote.
Where's my?
The clarification is the one is to take it out, and the other one is to.
Just take it out and treat it as a separate motion. Take the cultivator and micro cultivator,
So,
put a moratorium on that in a second motion.
so I would say, the first motion is to amend section 331.4B and delete term number 3, cultivator, and term number 7, micro cultivator. And let me just make sure. That's it.
And you don't think you can remove just micro cultivator?
Or you can remove just micro, I guess, do you want to remove both terms or just one?
No, I was just clarifying, because I think we've been talking about, I don't know how I'm going to vote on it yet, but we were talking about removing micro cultivator, and you just mentioned both cultivator
Okay,
and micro cultivator.
but like I said, so that would be a motion then to amend section 3.4B7 to delete the term from the proposed regulations. And that would mean micro cultivators are no longer subject to the moratorium.
But it also opens up that it could happen anyway.
Correct.
So the greenhouses on Jimmy Hill, in the middle of that neighborhood?
Yeah. Yeah.
They could put a medical marijuana there right now too.
Yeah, but we don't have a regulation right now, so we really, it would be a building if they couldn't do it with a building, then to build a building, we have regulations for buildings. So they're not gonna drop it in the middle of a residential area because if it was a medical merit, they'd have to have a commercial building in order to do that.
So I was just to speak to the medical marijuana, because I actually have experience with that too. The state, the facility that was in Simsbury actually wanted to expand and put commercial greenhouses in the expansion, 60,000 square feet worth of commercial greenhouses. It was actually denied by Consumer Protection. They said, no, it has to be in a building.
Yeah.
So they're actually doing a 40,000 square foot addition as we speak to that particular facility. And it is the same industrial block construction as the existing facility. So if it was a medical facility, they're going to be required to build a building, not just
Not just a random greenhouse.
So that being said,
not be able to use a greenhouse
yeah.
under current consumer protection regulations, which, as we know, down the road could change.
But a micro grower could use a greenhouse.
No, it's gotta be endorsed.
No, he just already said it was a greenhouse and you got to do a fence. Fence at a greenhouse, you got it good.
The
building.
medical program says you have to be in a building, not a greenhouse, but the recreational has not made that, they have not made that determination that they're going to say no to greenhouses at this point. So you should go with the assumption that they can use a greenhouse.
And I just, again, I'm concerned
think it's
because
too
we
much
have
risk.
one person that came in. I have sympathy for him. I understand he wants to do his business, but he's the one that we know about. We don't know if anybody else in town that has a greenhouse possibly can go for one of these lotteries, because we're gonna have the first lottery, then as he said, we're gonna have another lottery coming up. And I don't want to sit here and have residents of Cheshire coming in and saying, why did you allow this in my neighborhood? Because we took something out. I just don't want to do that. Because it could happen with the current lottery in February, the next one coming up, or the next one after that.
So why don't we vote on the motion which excludes micro operations? And if that loses, then we vote on the other one. If that wins, then we've excluded it. But then we at least move it along for tonight, right? It seems to me that makes sense to do it in that order, I guess.
Agreed. Agreed.
So we're voting on
Somebody has to
motion.
move the motion excluding micro.
I'll restate the motion. So the motion is to delete from section 31.4B, term number 7, micro cultivator.
From our motion.
From the proposed text.
Okay, that was it Natalie and Strollo? I forgot who,
No, actually, I think
They made a motion for the thing as a whole.
If Marilyn was here, she'd say there's already a motion on the floor, I guess. It was made.
we're amending the motion though. We're amending the motion to take out micro cultivator. That's why I need approval, I think, correct from
Right, I'm sorry.
the maker and the second.
Mr. Chairman, maybe
Yes.
you just have the gentleman withdraw their motion first. And then why don't we'll go with this motion first to amend section 34.B7. So it's clean. So you're not modifying that, just in case that fails and we're not.
I'll withdraw this.
Okay. Okay. So then, so the question would be, is a motion to, as I'll state it one last time, is to amend section 31.4B to delete term number 7, micro cultivator, from the proposal.
From our original motion. That's why I don't understand why we deleted our original motion.
Just so, my only concern was then your motion on the table is going to be the moratorium with that, with the deletion.
With an
I think-
amended,
I think you should amend the regulation, vote on the amending the regulations first, whether you're going to keep micro cultivators in, then the motion for the moratorium, because if that fails, then your motion of the moratorium is as is.
okay, so this motion is to
If you make
exclude
just micro
micro
cultivators,
cultivator from our motion.
correct.
Okay. Do I have a second? Do we have a maker and a second? To exclude. This is separate.
You need
I
a
don't think
fresh,
that motion hasn't been made to exclude yet, has it?
I just read it.
He just read it.
Somebody has to move it.
Someone's got to move it and
That's what I'm
second it.
waiting for.
I'll move that.
Moved by Mr. Strollo, seconded by Ms. Downs. Okay, discussion on this motion.
I still think it's the wrong.
I don't think we should do, I personally don't feel that pulling it out, at first I thought it was a great idea, but then I started thinking, what he said, when people said that now anybody can go anywhere, and we're betting on one guy to win the lottery, but everybody buys a ticket, you know what I mean? There could be some other guy out there that we don't know about, and we can get it, we're in trouble.
There's a lot of groups,
And then there could be a lot of grievance that comes with that. I mean, just because we're protecting one guy doesn't mean we're not protecting everybody else. I just,
I'm not saying I'm protecting one guy. I was protecting everybody else.
I don't know. I just don't, I think it's just too much of a risk to vote on. Vote yes.
I agree.
Okay, well, let's vote. And all those in favor of the motion signify by raising their right hand. 1, 2, 3, 4. All those opposed? 1, 2, 3. And anyone abstaining? 2. So the motion carries 4, 3, 2. So that takes it out now. Now we rehear the motion with it out. We make another motion.
Yeah, you should, just to make it clean, so. Be resolved, whereas the Connecticut Public Act 21-1 entitled Act Concerning Responsible and Equitable Regulation of Adult Use Cannabis, which legalizes the cultivation, processing, in possession of the cannabis marijuana for recreational purposes was signed into law June 22nd, 2021, and became effective July 1st, 2021. Whereas the law is lengthy, complex, and raises novel legal, planning, and public safety issues, and requires that the Cheshire Planning and Zoning Commission study and assess the potential impacts of the law on the town of Cheshire and the need for potential regulation of cannabis establishments as defined by Public Act 21-1 in a thoughtful manner, to undertake planning process to consider amending the zoning regulations regarding regulations of such establishments, and whereas a moratorium will allow the Planning and Zoning Commission sufficient time to undertake the required assessment and planning process, including receipt analysis of input from town officials, residents, and property owners and others. Now be resolved, the Cheshire Planning and Zoning Commission shall not accept, consider, or approve any applications except for micro cultivators, and hereby prohibits the issuance of any zoning permits to permit cannabis establishments in any zoning district in the town of Cheshire for a period of 12 months, effective January 24th, 2022.
Anyone want to move it? Move, Mr. Tedesco, seconded by anyone? Mr. Selma. Any discussion on this motion? Mr. Natali.
I will be voting in favor of the moratorium. But I do think that we made a mistake approving the last motion. Because again, I don't want to sit up here. If somebody applies for the license, they win the lottery, and they put it in somebody's neighborhood, I don't want to sit here and have to explain that. So I just want to go on the record. I think we made a mistake there, but I will be voting in favor of the moratorium because it's the right thing to do.
Okay. Any other discussion on the motion? Okay, all those, I'm sorry, Mr. Strollo.
I agree with Mr. Talley. I think it's complete craziness, but this is where we are today.
Okay, anyone else wishing to speak? All those in favor of the motion signify by raising your right hand. 1, 2, 3, 4, 5, 6, 7. Anyone opposed? Opposed 2, and anyone abstaining? Obviously not. Okay, so Mr. Kaderis and Mr. Dawson were opposed. Motion passes 7-2. All right, thank you. No, I don't think she had an easy one with the last one either.
She'll call me in the morning.
She's got the video.
All right, so we have 2 tabled for 2/16, not 2/14. We changed the date. Bonds, we have maintenance bonds released for
Yep.
2.
So you have a motion first for Stroller Court in accordance with the memorandum for the engineering department dated January 14th, 2022. The Planning and Zoning Commission authorized the release of the maintenance bond for the Cedar Crest Subdivision Stroller Court.
Moved by Mr. Vitale, seconded by Ms. Downs. Any discussion on this? Seems pretty cool. All those in favor signify by saying aye. Aye. Anyone opposed? And Mr. Strollo was abstaining. Okay. How about a maintenance bond for Clearview Farms?
In accordance with the memorandum from the engineering department dated January 14th, 2022, the Planning and Zoning Commission authorized the release of maintenance bond for Crestview Farms Preserve Beechwood Court.
Moved by Mr. Talley. Seconded by Ms. Downs. Any discussion on this motion? All those in favor of the motion signify by saying aye.
Aye.
Anyone opposed? Anyone abstaining? Motion carries unanimously. All right, there's road acceptance, right?
Yep.
Yeah. Oh, and yeah, Mr. Dawson is leaving the meeting, so Ms. Blake is taking his place. Road acceptance for Monarch Place.
In accordance with the January 14th, 2020 letter from George Nowak, Director of Public Works and Engineering, the Planning and Zoning Commission recommends that the Town council accept Monarch Place in its entirety as a town road, as shown on map entitled Subdivision Map of Coleman Farm Subdivision 678 Coleman Road, Cheshire, Connecticut, which is recorded in the Cheshire Land Records as shown on map 4726 and 4727. Acceptance by the town council should be conditional upon recording of a warranty deed for the town right-of-way and related legal documents approved as to form by and content by the town attorney. At the time of acceptance, the existing performance bond may be released and a maintenance bond for $27,651 be posted per section 10.14 of the subdivision regulations.
Moved by Mr. Tally, seconded by, nobody wants to second, Ms. Downs. Any discussion on this motion? All those in favor of the motion signify by saying aye. Aye. Anyone opposed? Anyone abstaining? Motion carries unanimously. New business, Cheshire Academy.
They'll come in for a special permit. It'll be the second meeting in February. We're going to run that legal advertisement.
Okay, site plan application for Gagson LLC.
You'll see that actually,
With
they,
2 and 3 together.
the 2 and 3 are together. The Wetlands Commission met last week, determined they're going to require wetlands permits for this application, so you probably won't see that till March. Unfortunately, he jumped the gun and submitted to us.
Okay. Anything else come before commission tonight?
That's it.
All right, I'll entertain a motion by Mr. Kadera, seconded by Mr. Selmont. All those in favor? Aye.